dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.
And you're back on Liberty Nation Radio, continuing our conversation with Liberty Nation's legal affairs editor, Scott Cosenza, Esquire. Scott, we've been talking about the upcoming cases for the new Supreme Court term, and a couple of doozies so far. If you haven't seen that segment, go back and watch it. It's superb. But I suspect you're saving the best till last for me, Scott.
Not necessarily, no.
In that case, watch that last segment twice.
We're recording this the second week of September, and one of the things we've seen in recent previous years is that the Supreme Court has added some really blockbuster kind of cases after their return from recess, and before they start in October, or as it's ongoing. So the best is not necessarily present, but some interesting ones. This is the kind of case that I really like because of the way it impacts preconceived notions in politics. This Landor versus Louisiana Department of Corrections involves this Mr. Landor, who was a Rastafarian who did not cut his hair for, I don't know if it was 20 or 30 years, but a significant length of time, and then was transferred to a penitentiary in Louisiana. And a guard or warden there decided that his hair was not well kept and not commensurate with that institution's requirements, and ordered him to be restrained and have his hair cut involuntarily from his body. And he gave the guy who the decision maker in that little moment, maybe not like the head of the thing who wasn't in the room, but he provided a copy of a federal court order that said that the Louisiana law that allowed that was violative of his federal rights. And so he's got a claim. Now, here's what's kind of peculiar about this case. He's suing individually. He wants to sue the person who ordered it done, because basically it's like the giving of the order says, you've been presented with this order, you've chosen to ignore it, so you willfully violated the federal court ruling. I shouldn't just be limited to suing the Louisiana Department of Corrections, for instance, but I should be able to sue you personally, you, the employee who did this to me. And if you flip the facts around, okay, and make it a kind of more conservative-friendly exposition. So if it was a bureaucrat in New York City who denied somebody their gun permit because they didn't like it, even though the federal court said you have to issue this, or something like that. You know, we could think about these things on different sides of the political spectrum. Do we want the ability to hold individuals personally liable when they violate the rights of others in their roles as as government actors? So I think that maybe we won't, in the end, reach that decision on the merits. Something we, might mention, just because it's always good to refresh people's understanding of the court. A lot of times they don't get to the actual issue that we might think is the issue in the case, because number one, they're motivated not to. If they don't have to extend themselves to change a law or overturn something, they'd prefer not to. So if there's a statutory or standing reason why Landor might not get his wish, like, you'd expect that. But in any case, we'll keep up on it. There's a case about political financing called National Republican Senatorial Committee versus the Federal Election Commission, which deals with whether or not candidates and whether candidate committees and the candidates themselves may coordinate messaging with political parties. There's a prohibition on doing so because of campaign finance law. J.D. Vance and a number of other senators sued, obviously it's back when he was a senator, to say this should be abolished. It's an impermissible imposition on our free speech rights. Why can't we collaborate as we message? And I think that it's a no-brainer that almost all these, we spoke earlier about money being speech in some capacity. Well, where could it be more speech than in a political campaign where we're literally messaging about, what we want to do with the office that we're running for?
The loss of liberty is never more than one generation away. So, Scott, I want to ask you about, and you might not have the details to hand here, so I hope I'm not putting you too much on the spot. But I know a lot of people are, and myself, are curious about what we know regarding Trump's efforts to end so-called birthright citizenship. He said that he's made the case that people who are born to somebody who is here temporarily or here illegally should not be a U.S. citizen. And, looking through the people who actually wrote the Constitution, looking at their writings, he seems to have a point, doesn't he? That was their intent.
You have opened up a discussion for a seminar class on. We look to the plain language. I think there are many philosophies in how we. It's not like the Constitution says this is how you should examine whether a law is constitutional or not. There are many ways in which justices and others think that we should. I would think that we should look to the plain language. If the plain language, under the plainly understood terms of that language at the time, then we're good. And if not, then maybe we look to other things like intent, or we just say it's undiscoverable and we'll have to start, come up with something new. But intent is not devoid of value. It's just way less value than what's on the page. You can imagine if we were both legislators, looking at whether we were going to vote for or against a bill that's up for vote, our intent as to what that thing is may be express or whatever, but what's important is what the law says. And we may vote yes or no, not based on anything about our intent, but a specific, one word change, for instance. So that's the superior, what's on the page, whether it's the Constitution or federal laws or federal regulations, what's on the page is what they should go with. And then intent or any other judging should come behind it. As far as the birthright citizenship thing goes and the intent, I actually haven't looked at the intent much. It does seem to me silly to think that the founders would have wanted like the British ambassador's children to be U.S. citizens by virtue of their birth here shortly after he arrived in America, for instance. But we'll be paying attention and reporting on it on the pages of LibertyNation.com.
And final question for you, Scott. Do you think this coming session of the Supreme Court epic will be as interesting and fascinating as full as the last one?
No, I don't think so, because I think there's more maturity with the whole dealing with these Trump challenges. And I think Ketanji Brown Jackson will be a little bit more reserved and mature in her justicing. I guess we could see Sonia Sotomayor really, if the derangement syndrome, goes off the rails with her, it could be fireworks. But I feel like there's been such movement on such landmarks that there's always exciting things happening at the court. But in terms of like really blockbuster, like are the ratings for this season going to outpace the ratings for last season, Mark? I don't think so.
Well, seasons usually TV shows usually get pretty bad by about season 3 or 4. And we're much higher than that on the Supreme Court. Scott, thanks for being here.
Cheers, Mark.
And that's a wrap for this show of Liberty Nation Radio, heard coast to coast on the Radio America Network. I've been your host, Mark Angelides. I'd like to thank our guest today, Scott Cosenza, Liberty Nation's legal affairs editor. And of course, thank you, the listeners at home who take the time each week to tune in and join the fun. Please do remember, Liberty Nation does not endorse candidates, campaigns, or legislation. And this presentation is no endorsement.
We dismiss history at our peril.
Liberty Nation Radio with Mark Angelides.